The law of insolvency, Laws 362, looks at the law that applies when a natural person or a company goes insolvent. For a natural person, that generally means going bankrupt. You'll probably have heard of people going bankrupt, and the first part of this course follows what might happen in that situation. We look at the fortunes of a fictitious law student who sets up a small business to fund his way through university. Due to a series of unfortunate events, he becomes unable to pay his commitments and the bank files for bankruptcy. So what does that mean? It issues a bankruptcy notice. Once a person goes bankrupt, all their property vests in someone called the official assignee. But what property are we talking about? Are we talking about his KiwiSaver account? What about his dog? What about that inheritance that he's about to receive from his granny? And are there any alternatives that might be better for our student instead of going into bankruptcy? What about if our student had run his business through a company? Would that have made any difference? Would have made a lot of difference. Companies can also get into financial difficulty, but they do not go bankrupt. There are different procedures that a company can use if it goes insolvent. You will likely have heard about receiverships and liquidations from studying property law, but there are other things that a company can do. It could, for example, go into a voluntary administration procedure, and that is where a third party steps in and attempts to sort out a way forward for the company with the agreement of all the creditors. Or another option is the company could attempt to negotiate with some or all of its creditors a compromise of some or all of its debts. Often a bank will put in a receiver in order to get the debt to that bank paid. What does that mean for the future of the company? And who's keeping an eye on what the receiver is doing? In case, for example, the receiver attempts to sell off the assets at an undervalue in order to get the debt paid quickly. The last stage of a company's life is liquidation. This is when all the assets of the company are sold off and the creditors are paid in a certain order of priority. Law 362 looks at the interesting issue of when can a liquidator challenge a transaction that a company entered into prior to liquidation. It's not uncommon for a company to seek to put certain creditors into a better position by either paying them out or transferring assets to them so they get into a better priority position. You might have heard of the case of Fisk and McIntosh, where a fraudulent director ran an investment company that was a Ponzi scheme. There were no investments, but the public believed that there were. A very interesting insolvency law issue arose when one investor was paid out just prior to the scam being revealed. He got all his money out, but hundreds of other investors got nothing. Did he have to pay some of that money back? Insolvency law builds on company law and on property law. There are jobs for students in law firms with insolvency law expertise and also in accounting firms. And there are also specialist insolvency practices. Law 362 includes a take-home test and there is an exam at the end of the course.